I am going to begin by reading into the record a letter from Governor Baker dated June 29th, 2022. Dear councilors, I am pleased to nominate the following person to the position of Associate Justice of the District Court Circuit. I submit this nomination for advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. The nominee is Nicole A. Colby Longton of Shrewsbury, Massachusetts, to the position of Associate Judge of the District Court Circuit, which position was authorized by Chapter 206 of the Acts of 1988. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker. And with that, we can get right to witnesses who you've brought today, Attorney Longton, on your behalf, and we can start with Judge Eustace, if you like.
Good afternoon.
Thank you for being here.
Andy, Councilor DePalo, Councilor Hurley, Councilor Kennedy, and Councilor Duff. Councilor Jubenville. Almost 5 years ago, you gave me the benefit of your time and ultimately your confidence in confirming me as a district court judge. Every day since, I've done my best to serve in a way reflective of the trust you placed in me. Thank you for giving me that life-changing opportunity. I'll never stop appreciating it. Just as importantly, thank you for the kindness with which you treated me as I went through the process. Like every nominee, I had much weighing on my mind at the time of the nomination. Everyone I knew was pulling for me, including my father, who was at the end stages of a terminal battle with cancer at the time. He told me many times that he was hanging on with the hope he'd live to see his son become a judge. He did. I knew my dad attached some of the measure of his own life to his son's success. And your confirming me wasn't just a gift to me, it was a gift to my dad too. Your kindness to me during that process abated much of the anxiety I felt at the time, both professionally and at home. Not just for me, but for my entire family. Thank you for the way you treated me in the process. None of you knew me personally when I applied to be a judge, and even as we got to know each other, none of you knew about the health crisis my dad was going through at that exact time. The kindness you gifted me in our in-person meetings and conversations had an immeasurable positive impact without your knowing it. And that's the point I've slowly arrived at. What matters most in life is how we treat our fellow men and women as we go. I've taken the time to talk about this before testifying more specifically about the nominee because I believe this is the best test for those that appear before you in this honorable chamber. This is the best litmus test of how they will exercise the powerful discretion you may choose to vest in them. How have they treated others along the way up until the time of their nomination is the best indicator of how they will serve as a judge in the future. By that standard, confirming Attorney Nicole Longton should be among the easiest decisions I've ever had to make. Attorney Longton is the smartest, hardest working, most capable, and most ethical lawyer I know. But that's not why I'm here today. Because as impressive as her academic and professional credentials are, she's an infinitely better human being than she is a lawyer. I tell you 100 anecdotes to support this premise, but begging your patience, I'd like to share just 2. I'm asked all the time, what's the most memorable case you've had as a judge? And the ones that stay with me usually reveal someone struggling out of sight, out of most eyes, just an anonymous soul acting heroically, trying to get by day to day, like this case. It was a collection case against a single mom making minimum wage with a 5-year-old son stricken with cancer. The least of her worries were her credit card balances. Dismal credit scores don't really rate as a priority when weighed against whether your child will be alive for his next birthday. Her account balance, born from a desperate attempt for financial survival amid the medical bills, was around $6,000 when her account was closed and the credit card company sued her. Might as well have been $6 million for that mom. She had no way to pay it. Judgment for the credit company later entered, the debt then totaling $9,000 with the interest and attorney's fees piled on. When the judgment went unpaid, a second suit via supplementary process aimed at collecting the debt was filed, and another judgment, now $12,500 due to more interest and attorney's fees, entered. And then a few years later, something that rarely happens occurred. The mom paid the judgment, every cent of the $12,500. She worked extra shifts, she sold her car, she paid the entire judgment. A year passed and she got served with a new notice for a court hearing from that credit card company. The $12,500 she paid was from a judgment 3 years earlier. It didn't account for the statutory interest on the judgment since then or their attorney's fees, and the newest court filing sought another $5,000 from her. A hearing was scheduled. That's when I first got the case. The mom stood alone in the courtroom, her hands worn from worry. An attorney representing the credit card company stood confidently nearby, armed with case law, statutory authority, all supporting his claim for additional costs. I heard both sides and asked just one question. How's your son doing now? Much better, the mom said. Thank God he's doing great. Took the matter under advisement, wanting to take the time to write up a detailed explanation for my decision, and found entirely in her favor. Ordered that the matter be deemed paid in full and that no further collection efforts occur. This wasn't based entirely on empathy. I had some legal authority for it. But none of that is why I'm telling you the story. The story's not about me at all. Later found out that Attorney Longton learned of this mother's story and sought through public filings in the clerk's office her home address. Attorney Longton sent the mom, a stranger she had never met, a large anonymous financial gift with a note attached that read in part, I overheard your story in court and was so impressed. You're a true warrior, an inspiration to me. I hope this gift helps your family. God bless you. She soon thereafter got a written reply relayed back through Amazon from the mother of the sick boy, who wrote back to her, I have no idea who you are or why my situation impacted you as it did, but your gift and kind words mean more to me than words can express. I will pay it forward someday. Thank you. I was the only one that knew that Nicole did this, and I had promised her I'd keep her name a secret. She never wanted any attention for her beautiful gesture. And I hope she'll forgive me today for breaking that promise, because it tells you so much about who she really is. Story 2. Years ago, I began a toy drive in Worcester County when I worked as a bar advocate and matched other bar advocates with children living in homeless shelters across Worcester County. As the holidays approached, directors from each shelter would give me a list of gifts for each kid. I'd then pair them with a bar advocate, making sure that each child got one item from their list. That is until Attorney Longton got involved. After looking at the list, she inquired about how many were ensuring equal value with regard to the requests. Some children were asking for plain white t-shirts while others wanted electronics. Attorney Longton was concerned about how a child with a modest request would feel opening their gift next to a peer receiving something more generous. I explained the limitations of time and money and administrative bandwidth and ensured her the children were always happy to receive any of the items. Attorney Longton was polite but adamant that each child's gifts were to be equalized to the extent possible, even if entire wish lists had to be completed. She insisted that for at least one day, every one of those children who had already experienced so much loss at young ages would not feel any disappointment from a disparity in gifts. I wasn't sure that equity was a possible given the volume of the requests and practical limitations of our volunteers, but Attorney Longton was not dissuaded and offered to personally try to equalize the list. I vividly recall arriving at the home of her and her husband Steve that year, which we had used as a staging area for the gifts, and I could barely walk through the door based on the mountains of gifts. I soon learned that she had personally bought every gift on every child's wish list to add to the one that a bar advocate had donated. She didn't stop there. She made sure any mothers living in the shelters were given gift cards as well. She wanted them to know that the community supported them in their efforts at recovery. And as if she hadn't taken on enough work as it is, she'd continue calling the shelter directors up until the day of the delivery to see if there were any new arrivals, new residents living there. Because of her empathy and a deep understanding of the struggles of individuals facing housing insecurity, she recognized the likelihood that a mom or a child could appear without warning right up until the day of our delivery. In fact, one year in particular, this happened. A woman arrived in one of the shelters the day we were delivering the toys. She was 9 months pregnant. Seemingly no one at the shelter knew or expected her. And during the gift delivery party, we learned that this expecting mother was in her room, keeping away from the party, too despondent to come out and watch her new housemates open their gifts. What she didn't realize, what I didn't realize, what none of us delivering the gifts realized, is that Nicole Longton knew she was coming because she spoke to the shelter director right up until hours before our delivery. The director told Attorney Longton that this woman was arriving that day, but assured her she wouldn't be expecting anything, and Attorney Longton wouldn't accept that. She went out early that morning before appearing in court on her cases, packed her car with everything from a stroller to a crib to baby clothes. Like every one of the other extra gifts she got the children, she paid for it all herself. The new mom was overjoyed. To me, one of the most amazing parts of the story is that Attorney Longton wasn't there for the gift delivery. She never has been. Every year I ask her to come, every year she refuses to. She eschews any attention or recognition for her efforts. She tells me it's not about her. It's not about seeking praise or attention or recognition from the community. She just wants to help. Now, the older I get, the less I'm sure of. But there's two things I'm sure of as I sit here before you today. This nominee is going to use her seat on the bench to change countless lives for the better. Second thing I'm sure of is when she does, most of us will never hear of it. Her humility wouldn't allow for any attention for it. But the good that I am certain she will do, the justice, the kindness, and the mercy that she will serve with, the lives that she will better, will all trace back to you in this hearing here today. Thank you again for your time and for giving me the opportunity to see all of you again today.
Thank you very much. Counselors have any questions or comments?
Sorry.
I just wanted to say this was one of my proudest votes in 23 years, and I only hear good things about you, and I wish we could have cloned you.
The luckiest guy in this room, I'm sure of that. Thank you very much, Councilor DeVere.
It means a lot, and it's quite an honor to have him here to represent you. That was beautiful.
Thank you, Councilor.
Thank you.
Judge, I have to tell you, in the 12 years I've been here, that's probably one of the most compelling witness statements I've heard.
Thank you, Councilor. Coming from someone I respect as much as you, that means an awful lot to me. Thank you, Councilor Kennedy and Councilor Devaney. Saying my respect for you. You know how I feel about you. Thank you for that.
Most you're a good listener.
Thank you very much.
Does he listen to me?
And is your next witness ready, Courtney? Or Mystery?
That is a tough act to follow. Good afternoon, counselors. First and foremost, thank you all for giving me the opportunity to speak on Attorney Longton's behalf. It was a little more than a year ago that I was sitting here myself, and it is great to see all of you again. I can also say that a year after your vote, I'm probably even more appreciative of it, as I've enjoyed this past year so immensely. I was honored to be asked to speak on behalf of Attorney Longton and could not be more supportive of her nomination. While I could sit here and go over her impressive resume, I know that you've all had the opportunity to review it yourselves, and I've had many opportunities to speak with her. I think it's more important for me to speak of more of Attorney Longton's character than anything else. I've had the pleasure of knowing Nicole for the past 12 years, both personally and professionally, as an assistant district attorney in Worcester, an assistant clerk magistrate in Superior Court, and now as the clerk magistrate of the Leominster District Court. Nicole has always been someone that I look forward to working with. As an ADA, you never know who is going to be defending the case you were assigned to. Some attorneys you dreaded working with, and others you look forward to. Nicole is always someone I look forward to working with. She was respectful of all the participants, prepared, fair, open to discussion, and even-tempered. With Nicole, you always knew what you were going to get, and that always helped to move the cases forward smoothly and fairly. As an assistant clerk, my experience with Nicole remained the same. She was always prepared, always on time, and always someone that can be counted on to keep the session moving the way it should be. I knew that if Nicole was defending a case, the judge wouldn't be left wanting more from her presentation, could ask any questions that were deemed necessary, and could expect a well-thought-out response in return. She always respected the court and everyone else involved in the case, whether it be the ADA, the witnesses, the court officers, myself, or the judge. In my time as the clerk magistrate, I have continued to see these qualities in Nicole: respectful, always prepared, even-tempered, and a pleasure to have in court. In my 12 years in the courtroom, I've had many interactions with judges, both pleasant and some not as much so. I can wholeheartedly say that Nicole would be a judge that everyone would look forward to working with or appearing before. She will treat everyone with the respect they deserve, will always be prepared. She will enter a case open-minded and will preside over a courtroom the way it should be presided over. And as a clerk that still runs a daily session, I know she would be a judge that I would be thrilled to clerk for. I couldn't be more confident in supporting Attorney Longton in her nomination to be an Associate Justice of the District Court, and welcome any questions you may have at this time.
Thank you. Counselors, any questions for the witness?
Thank you.
No. Thank you very much for being here.
Good to see you, Madam Clerk.
To see you.
And I'll also add that we received many letters, and I know from talking to my colleagues, many phone calls on this nominee's behalf as well. So with that, are there any further witnesses here in support of the nominee? Is anyone here in opposition?
Want me to check outside, Paul?
Bring him in. Sorry, I know there's a crew waiting. So with that then, we open it to you if you have a statement you'd like to share, Attorney Longton.
I do, thank you. Good afternoon, counselors. I'm honored and humbled to appear before you as a nominee for the Associate Justice of the District Court. I want to thank the Governor and Lieutenant Governor for their faith in nominating me, Robert Ross and Lauren Green Petrino for all of their support, including Lauren specifically, who was available to me on countless after-hours calls. I thank the JNC and the Joint Bar for their efforts. DePalo, who's represented our district for the last 2 years. We did not know each other prior to my nomination, but he took the time to get to know me as a person and a candidate and support me through this process, and I'm immensely grateful. And I want to thank each of the members of this council, Councilors Ferreira, Ianella, Drubenville, Devaney, Duff, DePalo, Kennedy, and Councilor Hurley, who spent time with my application, spoken with me on the phone and in person. I want to thank you all for the work that you do. It's been a privilege and honor to speak to you about my candidacy and my desire to serve the Commonwealth. I'm very grateful to have this opportunity to earn your support today. And I also want to thank the wonderful friends and colleagues I have here in support of me, my witnesses, Judge Eustace and Clerk Magistrate Courtney Price-Orozco. I hold them both in the highest regard, and their words mean far more to me than they'll ever know. I pause to reaffirm my thanks to God. In my lifetime, I will not cry. I have already been blessed beyond all measure. The first and greatest blessing of my life was being born to my parents, Richard and Michelle Colby, 43 years ago. High school sweethearts, they've been married 48 years. They had my older brother, Richard Jr., and I very young. They did not get to go to college, but they dedicated their entire lives to ensuring my brother and I had every opportunity they did not. My father is one of the smartest men I've ever met. He's never missed a day of work in his life, an incomparable work ethic. My mother, same drive and dedication. She was a stay-at-home mom who devoted her entire life to making sure her family's dream came true. She's the quintessential Italian mother and now grandmother. Growing up, she was the de facto mother to the neighborhood. She fed all of my friends, my teammates, the whole neighborhood. She's now a stay-at-home grandmother, and she is the only reason I'm even here today, and the only reason I've been able to balance my large family with my busy practice. She's loved my children. She's cared for my children, as well as my brother's 4 kids every single day while I work. For my mom and my brother and I are included in this. Her babies have always come first. And as a result of her selfless devotion to us, I've gone to work each day with peace in my heart, knowing my children were absolutely in the best hands. They would be loved and nurtured and treasured. She is the epitome of unconditional love, silent service, and self-sacrifice. And in addition to my parents, I couldn't have asked for a better big brother. He's 3 years older than me. Richard Jr., family is everything to him. He moved across the street from my parents in the home my parents are still in the same home I grew up in. He moved his wife and 4 kids there because he wanted everyone to grow up together and the same close family support that we had. From the time I could walk, I followed Rich and his friends around the neighborhood doing whatever it took to keep up with them. I insisted on riding a bike long before I probably should have without training wheels. I learned to play every sport and hold my own with older boys twice my size. I would learn to take hits and get back up without even a hint of a tear. And I eventually followed him to Little League, where he had the indignity of being the brother of the only girl in the entire league. playing on the boys' team. Most older brothers would have cringed and discouraged it, but no one was prouder or more supportive. And he offers the same unconditional love and support today, to this day. And speaking of unconditional love, I would like to introduce my husband, Stephen Longton. Steve and I have been together for 22 years. He's a true partner in every sense of the word. His strengths and weaknesses are perfect complements to mine. I'm a classic type A personality. Steve is not. I make lists organizing every aspect of our lives and planning for every possible worst case scenario. He tends to lose the list, but then make me laugh about it. The names our kids' friends call us probably say it the best. I am Mrs. Longton and he is Mr. Fun Guy. Steve and I have come a long way together. When we first met in 2000, I had just graduated college. I was heading to law school. He was young. He was a broke lawyer who was buried in student loans, even though he had worked 2 jobs and went to law school at night. We were together already deep into 6 figures of student loan debt. And I warned him at the outset of that relationship that if he wanted a future with me, there was going to be no unnecessary spending until we were debt free. So my last year of law school, I moved out of my dorm and into his law school bachelor pad. It was a basement level studio in the North End with below market rent. It was also below ground and had no working oven or sunlight. Our kitchen table had 3 legs and a 4th leg that we used to prop up for appearances in case we had a guest, which we never had because we couldn't have possibly fit another person in the apartment. The only new furniture he was able to get in the first 5 years of our marriage was in June when the leases would turn over and he'd get to go shopping from the things our neighbors discarded on the curb. And much to his chagrin, even after I was in the big firm and earning a big firm salary and bonuses, I kept my word and our budget didn't change. So for the next 5 years, we stayed in that tiny basement, chipping away at our loans. And on payday, I would loosen the purse strings long enough to let him get pizza from Regina's. From the outside, I know it doesn't sound like a great time, but the fact is it was an amazing time in our lives. And I wouldn't change those early struggles for anything because they provided a very solid foundation upon which we built our family. Steve and I had a very unique path to building a family. The journey humbled me. It changed me in a way that no other life experience could. No matter what is going on in my life, I still start each day with my heart full of gratitude because there is a time in my life where I prayed for everything I have right now. And I've talked a lot about the support of my husband and my family, but there's one person I didn't talk about yet, for whom I am eternally grateful. My children's biological mother. I'm the mother of 4, but 3 of these children were born to another woman whom we call Mama Kay. And I have my family by the grace of God and because she trusted me with these precious lives. I live each day humbled by her faith in me and dedicated to proving to her that I'm worthy of the trust she's placed in me. My children are my dreams come true. They're kind, they're generous, they're compassionate, they're wonderfully unique with their own interests and talents. There's never a dull or quiet moment in our home, and for that reason, my parents are home today with our young sons, Luke and Gianni, watching on the live link, or there would be no dull or quiet moment in this room either. I'm very fortunate, however, to have my girls, Allie, who's 14, and Lily, who's 11, here with me in support. I'm sure it has not been easy on them as I have navigated the challenges of balancing my practice with motherhood. I've joked to them on many days that being a trial lawyer and mom of 4 feels like I'm running on a treadmill in high heels while kids and clients shoot ping pong balls at me. It's been years of getting up before anyone else, going to court, rushing out to pick kids up, get dinner on the table, before homework and sports practices, fielding clients' calls and texts while arranging play dates and signing permission slips, reading police reports and deposition transcripts in the car between practices and orthodontist visits. And then each night after the kids are bathed and fed, I start my 3rd shift researching and writing memoranda of law and returning emails and preparing for trials. I know on most days I got the balance right, but on the days I didn't, I know I did my best and I hope they know I did it all for them. In my application and in conversations with each of you, I've discussed my education, my training, the breadth of my criminal and civil experience. I've represented clients in every type of matter that's addressed in district court, clients on both sides of cases, both the injured parties, the accused parties. I believe I've thoroughly responded to each of the questions on the application in an effort to demonstrate that I have the legal experience and personal characteristics necessary to be an exceptional district court judge. There are, however, a number of experiences that have not been captured on my resume or application that have been just as impactful in my personal development in judicial philosophy. From high school through law school, I always worked 2 or more jobs. I used my earnings to pay for my car, insurance, and to save money to put towards books and tuition. In high school, I worked for minimum wage at Burger King. I worked the drive-through, I hauled trash, I mopped floors, I cleaned urinals, and it was honestly one of the most important experiences of my life. I met people and saw struggles of people firsthand at 16 years old that enlarged my humanity and impacted my view of the entire world. I met a teenage mom who's my age and was somehow raising her daughter on the same meager paycheck that I could barely stretch to cover car insurance and gas money. A young married woman who was only 2 years older than me, but she came into work each day covered in bruises. And to my 16-year-old eyes, I thought her husband was very considerate, dropping her off at the door and faithfully waiting to drive her home after each shift. And it was months before I realized how wrong I was and the abuse she was suffering at his hands. And it was probably years before I truly understood why she felt she had to stay with him. Drew, a 30-year-old man with Down syndrome who came to work every day with a smile on his face and the most incredible outlook and sense of gratitude. I think he was named Employee of the Month. Every month I was there and it wasn't even debatable. None of us came close. To this day, I've never had a better hardworking colleague. After he would clean the parking lot till it was flawless, he'd pick a single dandelion and bring to me to keep with me at the drive-thru. He brought a smile to everyone's face. 25 years later, when I'm faced with significant challenges, I still think of Drew finding a dandelion in a sea of asphalt, and I'm inspired. During the summer, after my daytime shift at Burger King, I'd head to my second job as a waitress. And I always tell my children, everyone needs to work in fast food or wait tables at least once in their lives. Like most waitresses at this job, I worked incredibly hard, relying almost entirely on customers' tips. And many tables were very fair and generous, but more times than I can count, after diligently meeting the needs of a large table, my tip would be nothing more than a handful of change. And a few times it was unceremoniously left in dirty dishes of leftover ice cream. And despite my frustration at working hard and being forced to gather my meager earnings out of trash, I never let it get to me. I laughed it off and reminded myself to be appreciative of the money, even if I had to wash it first. And more importantly, to be appreciative that I was raised to never treat anyone like that. These varied life experiences and lessons helped me develop an extraordinary patience, kindness, empathy, and sense of gratitude. They're part of me, they're woven into my very fabric. If I were fortunate enough to earn your support, I would take these same lessons and experiences to the bench. I recognize that a judgeship is at its essence a position of service to others. It's a position of immense public trust. And I truly believe the most successful judges are the ones who are humbled by this honor. I'm fortunate enough to be confirmed. I will work tirelessly, honor my oath, and conduct myself in the humble and dignified manner that is consistent with the honor a judgeship deserves. Thank you all, and I welcome any questions from you.
Thank you very much. And with that, we can turn to my colleague, Councilor Hurley.
Hello there. I will confess, I had a case with Attorney Longton quite a number of years ago. She was described in one of the letters as someone who was cordial and polite, tenacious when it came to her client's position. Wasn't a big case, but she certainly was someone that I could deal with, as a matter of fact, it was a pleasure dealing with. And unfortunately, a lot of times the folks in Western Mass are not treated as respectfully or kindly as they should be and could be by lawyers from Worcester East. So she was great. And if I'd known, in your letterhead, you would put all of these things: super duper lawyer, rising star, top national trial lawyer, top 40 under 40, recognized as one of the top female attorneys in Massachusetts for at least the last 10 years, on and on and on. If you put that on your stationery, I would have been terrified. Well, not really, but it's a pleasure to see someone who has done so well in succeeding in the profession. But I think the better part of your life is your 4 kids and your husband. Obviously, you couldn't do what you do without a great partnership. And mom and dad, as always, play a super part. So Ally, can you stand up for a minute? So you're 14 years old. Yes? What school do you go to? I can't hear you. You'll never be a lawyer like your mother if you don't speak up louder. There you go. So, now this is an important question, Ally. Do you think your mother should be voted on favorably to be a judge? No coaching the witness.
Hesitation.
It's okay, you can answer. You're fine, honey. You might want to turn to Lily. Let's turn to Lily.
Huh?
It's just, you're fine. Help out your sister, sweetie, you're fine.
There's a ball.
What do you think? All right, great answer. Okay, I'm sorry, I didn't mean to put you in a bad position. The fact of the matter is, she's gonna have more time to be with you guys. All right? And I think that's probably one of the reasons why she's doing this. But you're lucky to have a great mom and dad. I didn't mean to scare you.
Yes, we
Counselor,
all the time.
Counselor Ally prefers to put
guys.
writing. She's a beautiful writer, but she does not like to be put on the spot and will never answer a question.
That's okay.
Correctly. She'd rather not answer, but
All
she'll be.
right, so
But Lily,
thank you. I'm gonna vote for your mom, okay?
there's no question you could ask Lily that she's not confidently going to answer, so they work well together.
Perfect. So I think you're just most importantly, just a great human being.
Thank you.
I have one dog. I've had one dog at a time. I had some stepchildren. Yuck. And for me, taking care of one dog is as much as I could do. That was it.
Too.
So, thank you very much,
Thank you.
and I intend to vote for you.
Thank you very much.
You bet. Take care.
Counselor Hurley, I'm very sad to hear that Worcester attorneys would treat our brothers and sisters to the West.
Well, that's before I met you.
Any disrespect, but we all need to stick together outside of 495, don't we?
Absolutely. Well, thank you.
Counselor Juvenville, do you have any questions?
I do. I looked at your work that you filed. The case, I gotta ask you, have you ever lost the case?
My first two trials that were second,
Would you put in here you won?
never,
I'm saying, why are you leaving the practice of law? You must be making a fortune, you never lose.
very well, and I enjoy it, and I have never lost a trial since I've been on my own. My first two trials were in federal court, and they were both losses. I was not the lead attorney, but I knew, this person with the CJA appointed criminal case with a full confession to the grand jury.
How many jury trials have you had?
I think total, I don't have the breakdown of jury, I've had more than 30 now.
You've never lost one.
And I can tell you that number would be significantly higher in terms of trials, but I win on a lot of motions to dismiss, 3G motions. I file a lot of motions to suppress.
You must be going before judges that, that's a Kenny and I never get to go before.
Not me, I lose all
It's
the time.
better.
Wow. You ever had any jury weight trials? You decide whether or not you're gonna jury weight it.
Now, and there's certain judges that I would feel very comfortable based on my years of experience in watching other attorneys try cases. I always would select a jury. I did not ever waive a jury for many years in my practice. Changed into waiving jurors. That's not in.
So what do you use to decide whether or not you're gonna jury weight it?
If I've seen a judge previously handle a bench trial and I thought that they fairly and accurately law to the facts, I would feel comfortable doing that. But if there are some judges who I've never seen have a bench trial or an acquittal on a bench trial, and I would not feel comfortable giving my client's right to a jury.
Do you ever ask the opinion of other lawyers about judges?
Sure, in the first half of my career, I still occasionally will, but I pretty much know all of the judges. Now I'm in Worcester County. If a new judge would come in, that's typical to ask other colleagues, are you familiar with this judge? But as a general rule, I prefer jury trials and have a comfort level with a judge.
So if you're on the bench, are you going to be a judge that people say they feel comfortable with jury waiving it?
Yes.
Because I make the decision based on what I know of a judge and what I hear about a judge. Are judges that in my 43 years, I would never, ever jury waive because they've never said the word not before guilty. Have you ever heard of any of them?
Yes.
So, what kind of a judge, what are we going to say about you after you're on the bench?
I would hope that people say I'm fair and I'm absolutely somebody that you can go jury waive.
My view is that some judges, although they understand the burden of the Commonwealth, they look for everything they can to substantiate a conviction for the Commonwealth. There are other judges with an open mind, look for and hear, look to hear. They would consider some doubt, some reasonable doubt. To me, that makes all the difference in the world as to whether I'm going to jury waive it. So let's assume the case is in your court and it's ready. The parties have picked a date of trial and they show up on that date. And you've got jurors that have come in and they say, we've reached an agreement, we want to tender a plea. You're going to say,
I'll hear the plea.
what about the jurors that were running?
Thank you for your service. I would see if the plea goes through. Just because they're tendering a plea doesn't mean it's a plea that's going to be agreed upon or one that I would be willing to accept. And if it doesn't go through and it's not something that would need another date to be executed, then it still have a jury trial. But if they are intending to tender a plea and it's a reasonable plea, I don't think the fact that jurors appeared means that we need to have a trial. If we can resolve a case for all parties.
Do you think a defendant has a right to plead no matter what stages of the proceedings, except after a guilty by a jury? Okay, so even if the jury's been paneled, they're out deliberating, and the parties say, hey, we reached an agreement on a plea, you think a defendant has a right to do that?
I do.
Would do that? Now, in what cases would you not agree if the DA and the defense lawyer, who probably know the case a lot better than you as a judge, tender a plea? Under what circumstances would you not accept that plea?
They're not going to know more about the case than I do, because if they're putting up a plea and they want me to accept it, I need to know the relevant facts about the case. If there's a disparity between what I think is appropriate and what the parties are suggesting, I would need some explanation for that, whether I need a sentencing memorandum or documentation for what they're requesting. Otherwise, I would think it would be, I can't conceive of a situation where I would be so wildly different in terms of an outcome than both the Commonwealth and the defense counsel.
You think you would know the case comes into your court for anything, and the parties are going to plead. You would know more about the case than the DA, who's had the case probably for 6 months or a year, and the defense lawyer who's had the case for a year.
I would know as much as I need to know on a plea. So when I know from my practice, when I'm putting up a plea and it's disparate, or it's something that at first glance a judge is not going, there's a sentencing memorandum, there's full documentation. I'm not saying, he wants to get into counseling, judge, and that's why my recommendation is no jail, even though he's in counseling, and here's a letter from his counselor, and here's a letter from his psychiatrist. Everything is well documented. So if the parties are at a conclusion for a specific plea, I would think if all parties are, I'm probably going to find it to be a reasonable disposition. If I'm not, it's because I'm missing that information, and I would ask counsel to provide it to me. Tell me why I should accept this plea.
And that's what they do. You hear from the Commonwealth, they state what they expect the case to be and what they can prove. And then you hear from both parties on sentencing, right?
Sometimes they're in agreement and sometimes they're disparate. And if they're disparate, I would expect it to be explained as to why they're taking such different views of this position.
But you hear from the lawyers, right? So the defense lawyer would have a different than the DA, and the DA has their opinion, and the defense lawyer has theirs. And you would make the call, right? A little unusual, isn't it, to ask for a sentencing memorandum in the district court?
I don't think it's unusual. I think it's, as an attorney,
I've never had one in 43 years.
I've never.
Superior Court, sometimes.
I've never put in an unagreed plea without one, and often I do one ahead of time to speak with the Commonwealth if I anticipate that it's going to be a disparate. For example, if it's a significant substance abuse issue or a mental health issue, I always do that ahead of time. I'm not going to require every attorney, and I would never expect the court to require that in every case, but there are some cases that are so significant, or there's extenuating circumstances, or a background really needs to be told to justify why you're making a certain request. And I find that it's very helpful to the court. It's certainly helpful, I think, and it's worth an investment of time, because judges have said it to me over and over again. You know, when I first looked at the record and I first looked at the chart, I didn't know what you were asking. Now that I've stepped it back, looked at the sentencing memo, I understand. Same with the Commonwealth, that would have firmly be in a position of this is a jail case. And then after looking at a suggested sentencing memo, coming to an agreement. And oftentimes those end up as agreed dispositions or very, very close together in terms of those resolutions.
Do you think things in district court are that serious that you've got to have them produce a sentencing memorandum and you're going to have to come back again for another day to argue the plea?
I've never had to separate it out and have it on another day. I don't know if maybe the sentencing memorandum can be as simple as a few pages outlining the bio, background.
Couldn't I tell you that as a lawyer?
But I like to see documentation. I like for the court to see documentation and for the Commonwealth to know it. It's not a.
Why did the documentation mean anything other than what the lawyer told you?
Sometimes the lawyer's repeating what a client tells them, and I would like to verify. So I don't want the.
So if my client tells me something and I argue that in my plea, you're going to say I want a memorandum, and I'm going to take a memorandum, and I'm going to sit there and I'm going to write the exact same thing that I just told you because that's what my client told me. So how are you going to, what are you going to do with that to know whether or not, it sounds like you're not going to believe it. So you want something in writing so you can believe it.
Well, I would say to the attorney, okay, you say that the client's in counseling. Tell me about that. How often does he go? How long has he been going? How many times?
And I tell you that.
You're an officer of the court. I mean, I understand that, but I'm telling you.
You're going to say, well, I'm on a memorandum now.
No.
I want it in writing.
Just to be clear, that's my practice, and I'm not saying there's any bright line rule. I just found it's very effective, and it has been very helpful to the judges I've spoken with, that they appreciate it. It's certainly not in every case, but it is something.
I'm going to predict that probably 99% of the lawyers that practice in the district court, where most of the cases are cases that end up in some probation programs, and probably a very small percentage end up in somebody going to jail. Would you agree with that?
Overall percentage in district court, I mean, I think more often than not, yes, it's probation, other disposition law.
I mean, rarely does somebody go to jail in the district court. I'll bet you it's not more than 10%, if that. And it's usually a mandatory, something like a third offense OUI or a fourth offense OUI. But other than that, the great majority of people end up taking a suspended house sentence, and even that isn't done very much anymore, and probation with conditions. I guess I don't see the need of, just because you did it, that you're gonna make all the other lawyers do these sentencing memorandums.
I didn't say I would make them do it. I just said that's been my practice. And I would expect that if an attorney is standing before me, they're an officer of the court, they're telling me the truth. But I do prefer to have documentation. I don't back away from that. If
They can't give you documentation.
a client completes a program, I would
I'm
expect.
gonna tell you that. So you're gonna say, I don't really believe you, Jubenville. I'd like to see it in writing, and I'd like to see documentation that your argument is actually truthful.
Well, I think we do that. You see that in the probation department. There's a reason we have probationers sign release to confirm that probationers are attending a program, completing a
But they
program.
usually haven't started them yet. They haven't been found guilty, or they haven't pleaded yet.
So if we're asking the court to give a certain disposition because this defendant has done so much and has completed a program done, I would think the same level of diligence. And again, it's not a bright line rule that if you were to appear in a court, you need to do this. I was simply explaining my preference, which I've been told is different than what a lot of people do in district court. But I do find it's been helpful, and I don't take the view that it's just district court, so is it really that serious? Because it may be not the most serious case I've ever had on my desk, or certainly not the most serious case you've ever had on your desk, but to each individual client and to the victims on that case, that is the most serious thing on their desk. So I always tried to give it the same level of attention, because that's the only case that matters to them. And I would put myself in their shoes, whether for all of the parties. And in the vast majority of different district court cases that I've had where there's been a true victim, a lot of times it's a family relationship, whether it's a domestic or parent-child. A lot of them are very gratified and affirmed to see programs being completed, to see that. And unfortunately, with cases like with substance abuse, with things where there has been a pattern of someone maybe letting down family members, lying to support a habit, things like that, to have them say, oh, the lawyer said he did a program, but I don't. I honestly think that has helped from personal anecdotes from stories in so many cases to know it's a verified fact. It's not his defense lawyer saying it's true. He really did complete the program. He really did sign up for the contract.
Again, you're not gonna believe the lawyer.
That's not it.
Why else would you want documentation?
I'm an officer of the court, has an ethical obligation.
So I'm an officer of the court. I'm telling you that that's what my client's done. And you're saying, I don't care whether you're an officer of the court, I want documentation of it. Right?
I would prefer documentation. I'm certainly not going to take a position that anyone.
Let me ask you this hypothetical. Person's on probation for heroin abuse. And 2 months after they're on probation, the order is to refrain from heroin. And the person is violated by probation because they have a relapse. And the probation officer wants them to go into the house of correction. That's the only facts. Didn't commit a new crime, didn't do anything other than violate. Put them in jail. 2 months later, they're back again, they relapse again. Probation officer says, hey, this is the second time, Judge, I want them to go to jail.
No, part of recovery is there are relapses. I would like to.
The fifth time, he's violated. Nothing else, no new arrest, no new nothing, violated. To another 2 months, he violates. Fifth time, the probation officer says, Judge, this is the fifth time. I want him to go to the house of correction.
I don't see what the House of Corrections is going to do. He hasn't committed.
What's your answer? Are you going to send him to the house of correction or not?
I'm not inclined to send him on that. I would ask for, what has he been doing? Are there programs? Is he being supported? Is there an alternative is he just gripping his seat, hoping to stay clean, or is he doing something? Probation, there can be supports, there are programs that can help. And if he's not availing himself of those, or he's not aware of them, I think the court can help with that. He doesn't need to be.
Well, that's going off the field. First of all, I'll go by a side. Probation doesn't, just one word, probation doesn't supervise anymore, in my view. I love probation, my daughter's in it. They do not supervise anymore. The supervision for the $65 is peeing into a cup. And The fallback for some probation officers, oh, they violated, they should go to jail. They don't understand addiction. So I like the fact you wouldn't, I think you said you wouldn't put them in even a 5th time. But you're hesitant about that.
I would need to know what he's doing. I mean, I
He
think.
failed, he relapsed.
What's he doing for?
Nothing. He did nothing. He relapsed.
I would probably order a program or something to support him. I don't think jail's the last resort. If he's out committing crimes, different.
I'm going to interrupt you. In my view, jail is not the answer ever on an addiction. Any judge that puts somebody in jail on the sole purpose is, the only reason is they relapse, does not understand addictions, and shouldn't be sitting on a bench. You don't give him any credit for the 2 months he went clean, which is an unbelievable thing for a heroin addict to do. And, all right, I'll leave it like that. Thanks.
Counselor Devaney?
Thank you for all the time you afforded me. I really appreciate it. I really got to know you. I meet with everyone because I'm not just phoning with someone on this paper. I want to know the whole person. And I have to tell you, I can't think of anyone who has more compassion. If I won't go in, doesn't have compassion and empathy, and you do. And I'm not going to grandmother. I wouldn't have said it in front of you to others, but your life is amazing. It really is. I mean, to think you went with 2 children and came home and 4. I mean, that is truly amazing. Now, how old are the boys now?
They're 8 and 6.
Yeah. So everything is well. Yeah. Yeah. They all. I have 4. They didn't all get to. My son didn't like his brother. I think till he was 12 years old. So you're doing well.
They get along very well, but there are moments.
But just remarkable, and you know, your pro bono is amazing, and we don't see that. Most of them say, oh, I don't have time for pro bono, I can't, or my job doesn't allow it, whatever. Amazing. And you have gone that extra mile for people and kept in touch with them, and some horrendous cases. Tell me about the award-winning coach who was 35-year-old plus, and she was openly gay. She had gone through a lot of harassment. That was quite a thing. What is that, the Title IX?
That was a Title IX case. So she was an openly gay coach in the 90s. And at a university she was the victim of some significant homophobic attacks. Had a strong suspicion of who it was. There was an investigation. At that time, they just sort of swept everything under the rug. Fast forward 20 years, the Me Too came out, and there was an anonymous letter that she was this perpetrator of an attack going way back, and referenced decades earlier. So from the outset, it looked to me as a continuation of this attack. But the way it was handled,
Right, it was all anonymous.
So what was unfortunate is she was immediately removed, banished from the campus without a word. No opportunity, it was a gag order, couldn't speak to anybody while they investigated this. And the way they investigated it was pretty horrific. They asked very leading, loaded questions about her. Did you ever see this? Did you ever see this? So her reputation was destroyed in that period of time. I can tell you that after a year and a half, we had the final hearing. She had retained, back when email was new, she had printed emails. This never would have happened, but she had files. But what happened was after they investigated the Me Too Anonymous, they couldn't find anyone. No one ever saw anything. No one ever did anything. And then finally a woman came forward, a young woman, and said, I had a consensual relationship with her. It was inappropriate. And she kind of took it forward. And what it turned out was this young woman had significant mental health issues at the time, had kind of relied on the coach for a lot. And it was all documented in emails that the coach had taken her to the counselor, had done everything, went above and beyond. And she was 20 years later. She was off campus for a full year and a half. She was fully vindicated after a hearing, reinstated, and then was able to retire.
And you said that this Title IX hearings drove you to be a judge. You really think that?
seeing how those are handled, seeing how those investigations are handled.
As long as the camera
Seeing what it means for being a truly fair, neutral arbiter absolutely is what I would love. I loved balancing those cases with being able to go to court and actually appear in front of a judge, because you didn't have that in Title IX. The same people investigating the case were deciding the case on the merits and were circling the wagons around themselves. And had a very much a feel of a witch hunt.
Something about the Raymond Rivera case, that was, I can't believe it. I mean, they even found it was babies in the closet. I mean, I can't believe that I don't know how you went home and slept at night having these cases. God bless you.
That was a very difficult case. It received a lot of news attention because of he was not sure anything related to the deceased.
Excuse me, could we stop the cell phones? Just be polite.
Babies.
I'm sorry to hurt.
The fetuses, he wasn't charged with that. He was alleged to have been the biological father of 2 children in the home that he was reportedly unaware of. He had 2 children that he knew of, and there were 2 younger babies that his wife had told him she was babysitting. And that case went on for years. I did submit a writing sample on that, and it was ultimately resolved.
I mean, things were dismissed. What actually, was it guilty of anything? Was there any sentence for this person?
He had a.
Because you know what it is, I've always said it, I don't know the rest of the story in the JC, and it's so, oh my God, what happened after that,
He received he was held, he was on a very high bail, he was held during that period of time. He was convicted on, I don't remember the precise charges, but I know the charges that were dismissed were the ones that were the subject of that writing sample, which was, could you be, he was biologically the father, but at the time he didn't know. So really the issue was, if the statute requires you to be a parent in order to have criminal liability, if you don't know you're a parent, could you truly be criminally liable for not protecting this child that you're unaware of? Is there a duty there? So that argument was unsuccessful in a motion to dismiss, but it was ultimately part of the plea agreement. It was.
I really love to have someone with, and their solo practice. I think it's different, the way I see it. If you just work solely as a district attorney's office or the attorney general, you give him the client. You choose who you're going to represent. And not only that, the police give you a report, so you're halfway there. So, and the other thing, you're responsible for shoveling the snow and for the rent and all of that. And I think that makes you more a concern and more compassionate when people come in and they have a lawyer and you know what they're charging the lawyer and everything. And you've done so much pro bono work. I haven't seen like this. It's remarkable. And all I can think of is you're a young woman starting law practice. You're sitting there waiting for people to come in. I'd be petrified. It's an amazing thing what you've done, what you've accomplished, and the awards that you had gone. I'll get into that. But you had a wonderful. It was really. It had a good, not starting right, but it had a good ending about the client that you had coming from the streets of Puerto Rico. That was beautiful.
He's doing really well, actually. He has this will be his 3rd child, but his 2nd baby in a few years on his way on with his wife. So he grew up he was on the streets of Puerto Rico from a very young age, in and out of the system, pulled a very big sentence, and spent basically from 18 to, I want to say, late 20s in prison, and then ultimately, I believe, ended up in the House of Corrections for a stint. I mean, within weeks, he had no time as an adult as part of society, no support for family. He had a child who he had fathered, I believe, right before he went in on the long bid. He got out, had nothing, nowhere to go. He was living in an abandoned Yukon and bathing in Bell Pond. And he used to survive just day labor jobs. And I was introduced to him because I had helped a woman pro bono who was the victim of domestic violence, and through her employer. In any event, this young man was working day labor and was working so hard, He ended up getting a real job with a local employer who helped him completely turn his life around. What wasn't clear is that this young man wasn't on his record of drug use, but he had a substance abuse issue. And when he came out with all the trauma he had experienced, he was back on and off drugs. And probation, to their credit, recognized it, got him into programs or tried, and then COVID hit, and there weren't beds, and there weren't. So he ended up having some driving charges that were fairly significant, and he was going to be held. And I did a sentencing memorandum, and I did everything to try to get him out, and Judge Richardoni in Superior Court said, "You've done tremendous advocacy, get him a bed in the next 24 hours, and I'll look at it." And the bed we found one in New Hampshire, which is my first choice program. It's called the Plymouth House. It's an excellent program, but it was expensive. And his employer said, "I'm going to pay for it. This is the hardest working guy I've had. He would do anything, and I'm going to support him." And he went in, he did the program. It was 30 days. He did the step down program. He got out. He paid off all of his, couldn't get his license back because of all the fees and fines. There's just so many obstacles when you're released. He got everything back. The woman who also works for this employer, they fell in love. They got married. He reconnected with his teenage son. He's a father for the first time, getting to be a father, fully paid up on his child support. And he and his wife now have one baby and one on the way. And he went so far from bathing in Bell Pond to now, they have a nice, lovely home, taking care of their children. And his substance abuse issue, that program worked miracles for him. We got him into outpatient care, so he constantly has that counseling support.
Just meeting with you for a long time and looking at your questionnaire and you have influenced so many people in their lives. And this young man has kept in touch with you. And that must be so rewarding to you.
Truthfully, it's through his wife. He's a man of few words, but she sends me, when they had their first baby, I sent him a blanket with the months, and I get a picture every month with the.
Tell me about this. You established women in the area. Tell me about that.
So Women in the Arena, when I first.
Arena, I'm sorry, Arena.
When I opened my office, there was one female judge. There were very few criminal defense attorneys who were female. There were very few there were a few defense attorneys who were female. There were a number of ADAs. Was very fortunate to have wonderful mentors, but they were all pretty much older men. So as my practice really developed and I realized there were women who wanted to do what I did, but didn't know how or didn't have the confidence, I actively looked for ways to help. And one of the things was to just be more honest about, hey, this is what you need to do. It's going to be hard. It's difficult, but let's support each other. And I got a few other experienced attorneys who were willing to give of their time and their resources, female, and we've built, it's very informal. I'm also the co-chair of the Women's Bar Association for the Worcester County Bar Association. So I see the benefits of the Bar Association. What this offers is a very informal way to quickly have resources and to have that support. And I just had this awful experience where I have this client, what can I do? Where I really want to go out on my own, but I don't understand things like malpractice insurance or rent. And it's a way to do all of that. I find that it's been extremely helpful to some of the younger considering it, just to bounce ideas off of. And it's been great to me.
But I'm surprised at your answer why you want to be a judge, because you said your life's purpose is to help people. And you've done it. I just can't imagine how many people are out there that you represented that are still in touch with you and you've changed their lives. If you hadn't been part of their lives, where would they be, But I do want to recognize that you have been recognized as Massachusetts Rising Star, super lawyer for criminal defense, 10 years in a row. That's amazing. And recognized by Boston Magazine as one of the top female attorneys in Massachusetts for each of the last 10 years. And recognized as a national trial lawyer, top 40 under 40. This is an amazing thing. You've had, how many trials? Could you count
Before I applied, I counted, and then I've had some since. It's more than 30 at this point.
Well, you know what? And I still can't get over it. 4 years ago, we had someone to the Superior Court, he had 6 cases in 21 years in Superior Court, and he went to Superior Court. Yeah, I could write a book. The political people can jump their line. I'm glad you got through. And it's remarkable, really, because
Councilor.
we need more people like you. We need to clone you. So,
Council, one
anyway,
minute before we go to council.
I'm tired for 15 minutes. You know why? Because when we were taking this vote to make it 15 minutes between you and me, someone said, one of the councilors said, there's one councilor that likes all the questions and there's no questions left. There's a million questions out there. I don't understand that. But I want people to know how qualified you are. You know, I mean, this is not a political appointment, and I just couldn't be more pleased. And tell me, how many people interviewed you from the JNC? How many were there? There's 21 lawyers that have the
Councilor.
responsibility to choose you to recommend to the governor.
10 were on the Zoom screen and 1 present. It was 9 or 10 on the,
So the total was what?
it's 10 or 11.
Thanks.
That's what I'm so
Thank you,
angry.
Councilor.
In this administration, there's never been more
Councilor
than
Duff.
12 out of 21, and they all vote. Thank God you got through.
Thank you.
They're going to time me, because they want to go to the next one, and I thank you, and I thank you for all the time you've given me. I really enjoyed it.
Councilor Duff.
Thank you for your patience.
Thank you.
You're a stellar candidate. I don't need to beat a dead horse. Folks who reached out to me about you were people that I have the ultimate respect for. Conversations that you and I had, I'm not going to rehash here. All of us spend a lot of time vetting the candidates in different, some of us meet, some of us talk, but every single one of us does the same due diligence. I don't need to rehash your resume or your cases with you. I feel very confident that you will do an outstanding job on the board. So I have no questions. Thank you, Mr. Chairman.
Thank you, Councilor. Councilor Kennedy.
Ask you a question, those 30 trials that you did, was that over the whole 20 years you've been out there?
So my first 6 years, I was in a big firm, and
I saw that, Will McDermott.
2 of those were, I was second seat, and there were a few trials there where I was, if there is a phrase, I was 12th seat. So I didn't count those. I wrote, and then after that, those were just trials where I was on my,
So what?
so since 2009,
What's your average caseload?
about 100 a year.
You do sentencing memorandum on all 100 of them?
Well, that includes personal injury, number 1, and number 2, no. It would definitely just be the cases where there's going to be a problematic disposition or disparate, significantly disparate.
I just want to clarify that, because I wasn't that clear when was asking the question. Because right now, I've got about 200 cases, partially because of the pandemic. It would be impossible to do sentencing memorandum.
It would be unnecessary if you have a very simple plea where all parties are on the, but I believe I was responding to him saying if the two parties were at a disposition and you're not there, well, obviously I'm missing something. If 2 experienced counselor at the same point, why wouldn't I be there? Throw it to me. What am I missing? Or tell me, but that anytime a judge is going to look at me and say, why are you asking me to do this? I anticipate it.
I just wanted to give you a chance to clarify that, because I'm not sure that really came out, that you don't have an expectation on every plea that people are going to be doing sentencing memorandums.
I don't think, no, because a lot of times they are stepped back and you can't step back 100 cases a day.
I didn't think that's what you intended to convey, and I want to give you a chance to clear that up. Now, the second thing, I just want to say one thing, and I'm not going to ask you any more questions. Lighten up. You've been working for 22 years to get here. You're here, okay? You don't need the level of intensity that you've been going at. You can burn out pretty fast in this job. And every day that you go into court, I have one request of you, and I've made this of many other judges. Start the morning with a smile and good morning. It makes a difference, setting the tone. We've all been there. You go into a court and, you get a pleasant judge like, I was going to say Judge Eustace, but I'll go with Judge Mehta. You go into court, there's a nice smile and good morning. Let's get to work. What are we going to do today? It sets the tone. It really does. And that's what I expect from you, to set a tone that starts with a pleasantries every day and it goes throughout the day. Okay, I think, one thing that I think you learned how to do is count at some point. Okay, you were counting as we were going, right? I assume? Votes?
I wouldn't be so presumptuous as to count a vote. I'm gonna wait.
Well, it sounded to me like you have them. Said, thank you, Mr. Chair.
Thank you, Councilor Kennedy. Attorney Longton, we had a great conversation or two coming into here. I don't have a lot of litmus tests, but I know from your opening that you lived in the North End. So is it Regina or Ernesto's? I heard Regina brought up, but I didn't really heard Ernesto's mentioned, so I didn't know.
It's a point of contention early on. I was from Regina, but I believe my husband availed himself of Ernesto's for many years prior to my stringent budget cuts being imposed.
You won again.
All right, under advisement. We heard some great testimony, by the way, from your witnesses. That was very heartfelt and persuasive. I wanted to ask you something that we talked about, and I hope you don't mind me asking. I'm a dad, and I'm a very active dad, and it's a challenge to juggle this. I'm not a mom. Are there unique challenges to someone who's put together the professional resume that you have to being a mom, to working in the courthouse and doing this work? Are there barriers in that?
I think when I opened up, I experienced barriers in the sense that it's so helpful when you're trying something that's challenging and going out of your comfort zone to see someone else who's doing it and to see someone who's succeeding. And I looked around and I remember there was Judge Guzman, who's now appointed to the federal bench. She was the private female defense lawyer she was the only one I met. And I remember her words to me right before she was nominated. I had no idea she had applied. And she said, "It's so nice to see a young female defense lawyer who's driven coming up behind me, because you do all of this work and you're turning around and you want to help the next person. It's so nice to see you." And I was picturing that she would be someone I could reach out to, and then she was a judge within probably just a couple months. But I was cognizant of that and mindful of that at a certain point I became one of the attorneys that other young women, whether they were DAs or from big firms or just wanting to open up, that were reaching out to me, or judges were putting them in touch with me. And I realized that I could help, because it was intimidating. I looked around for the model success for the pathway and I didn't see it, and I had to create my own. And I did have wonderful mentors, but there are unique challenges that any, working mom could experience. And there was, I learned how to deal with them. Maybe I didn't handle them the best, but I find that having a lot of people share their experiences has been extremely helpful to the women coming up.
Yeah, one of the reasons I feel so great about your nomination is I really believe that you're going to get in there and you're going to build a legacy of bringing people along with you. And I just see that in your work ethic and in your approach to things. I just wanted you to just briefly hit on why, strike that. You mentioned a couple programs that you've utilized for clients, or clients have utilized in the past. We talked about incarceration as a last resort, or as a means of protecting public safety, and taking a pragmatic approach to that. Is it important, in your estimation as a practicing attorney, that a district court judge would be familiar with the resources, the treatment, the programs, the diversion programs, the transitional services, the housing? Is it important that a district judge have kind of a localized feel for what's out there, for the resources that are there?
I think it's very important that they have that information. I think that you can develop that, but I think it's very helpful when somebody comes to the bench already aware of those things and then learns the details of the local programs and the local players who can connect them.
I know from today's hearing that you are you're very familiar with the impact that trauma has on people. What is the impact that trauma has on someone's development?
I think there's the scientific evidence, which is clear that it affects things like risk-taking and impulse control, and their ability to do what they need to do to be successful. There are barriers, and a lot of times it's unseen, and that's the problem, is it's invisible, and it might manifest itself in crime. So I think that's something that's a judge needs to be familiar with, sensitive to, and if not familiar with, become familiar with, because it's going to be part, everyone that stands before you may have a story, but the invisible trauma, that's really something that they have to be in tune to and aware that it could be driving a lot of the issues.
Okay. And so when we're taking into account brain development in our juvenile court, and the SJC says that we need to, that's appropriate. But when we know brain development is still continuing past the age of juvenile jurisdiction, how do we circle that square? To what extent is age and the childhood trauma, if it's there, that exacerbates the development, to what extent is it informing you as a judge in crafting dispositions or sentencing decisions?
I mean, I think I look at the age, I look at first and foremost, what does this individual, whether it's a child or a young adult, need to get back on the path to success? And if you're familiar with, or you become aware of the trauma and the background, and you take steps to make sure that that's being treated, I don't particularly care if that's a juvenile court issue or a district court issue. At the end of the day, is they're getting the treatment. But
is there room in your practice as a potential district court judge to inquire about potential childhood trauma?
I don't think that it would be appropriate for the judge to ask that, but I would certainly expect counsel to have a defense attorney to have. I can tell you again, my practice, when I have an individual come in, even somebody who reports no mental health issues, I strongly encourage them, and by strongly encourage, I mean, I basically have my assistant makes the appointments to get a mental health counselor.
Does every defense attorney have the wherewithal or the motivation or the initiative to do that? Because I doubt it, right?
PCS has a wonderful social worker. There are resources, and it's up to the attorneys to do it. I certainly wouldn't require it. I mean, sometimes someone's there for childhood trauma. Sometimes someone's there because he's made a bad decision and they led a very blessed life until that point. And we're going to be judged the rest of life.
Here's my last question for you. When I walk into the Worcester courthouse, what are the people working there going to tell me about you?
I would hope that I can tell this council, I've received just an outpouring of support text messages and calls. I couldn't believe the level of support and how far it had traveled, the news and people, I'm praying for you, and I was receiving texts with these great well wishes that I would like to think that is exactly what we're here, because it's people from all walks of life, from all throughout the court. When clients began finding out, I mean, it did spread pretty quickly that I had been nominated, and even when the due diligence process was going on, received words of support, but in the past few weeks, it's just been an incredible outpouring from pretty much all the courts in Worcester County.
I'm really confident I'm going to be proud of this yes vote that I make on you. I've been really impressed talking, especially actually talking with people in the bar community, besides just talking to yourself. Your reputation is very real and your work ethic is through the roof. And I hope that you do find that balance, like Councilor Duff was talking. And actually maybe it was Councilor Kennedy put it a little more bluntly, but I'm really excited at the possibility of you sitting on the bench. So unless there's other comments or questions, we will adjourn this hearing.